She's gone.
I think justice, however, needs to be served.
It took a lot for me to be able to even drive again.
I work tirelessly to keep drunk drivers off the road.
I'll never forget what I've done, and no matter what.
Valereen Kaleohano-Knittle is facing charges of first-degree negligent homicide and first-degree negligent injury in Hawaii. Until May 2009, she was an ordinary woman, but her life took a dark turn when she caused a tragic accident while driving under the influence. With a blood alcohol level 3 times the legal limit, she raced down the road, her speeding truck careening through a red light and colliding with a car carrying Aaliyah Braden and her mother, Mavelyn. The impact was disastrous, resulting in Aaliyah's tragic loss and critical injuries to her mother. It was a heartbreaking scene that left everyone in shock and disbelief. Outside the court, Wayne Braden tearfully expressed how much he missed his precious daughter while clutching her blanket.
Scent is gone. You can't smell her anymore.
She's gone.
Although the loss was heartbreaking, the events in court were deeply moving. Wayne Braden, Aaliyah's father, held a photo of his beloved daughter with a heavy heart as he expressed his grief and anger to the court. Meanwhile, Valereen Kaleohano-Knittle, overwhelmed by guilt and shame, tearfully addressed the court, her eyes filled with remorse.
I work tirelessly to keep drunk drivers off the road.
In a deeply emotional moment, Valereen pleaded guilty to her charges, expressing profound remorse and devastation. She acknowledged the pain and sorrow she had inflicted on the Braden family, and with tears rolling down her cheeks, she begged for forgiveness, knowing she could never undo the harm she had caused. What happened next was truly extraordinary. In an act of unbelievable compassion, Wayne Braden stood up, approached Valereen, and embraced her. The courtroom was filled with tears as the power of forgiveness and understanding took center stage. Even the judge, Elizabeth Strantz, was moved by this exceptional display of humanity. In the end, Valereen Kaleohano-Knittle was sentenced to 10 years in prison for her actions. Additionally, she was asked to pay restitution costs for medical expenses and funeral arrangements. Now living a sober life, Valereen Kaleohano-Knittle has sworn her commitment to preventing others from making the same mistakes. Her actions resulted from her intoxication, and her apology seemed sincere. Eric Windhurst is facing charges of murder in New Hampshire, coming from a dark turn his life took back in 1985. It all began when Melanie Paquette confided in him that Daniel Paquette, her mother's ex-husband, was molesting her. Filled with fear and concern for Melanie's safety, Windhurst made a fateful decision. Together, they confronted Daniel Paquette, armed with a gun. Tragically, the confrontation turned fatal, with Windhurst shooting Paquette from a distance. The case remained unsolved for about 20 years. However, Melanie later confessed to the police about their involvement in the crime. During the hearing, Windhurst spoke deliberately, expressing shame and remorse for his actions as he recounted the events of 1985.
I am so sorry. There's nothing I can do about it. But I am. I'm so ashamed of my crime. This will never end for me. I'll never forget what I've done, and no matter what, I'll always try to be a good person, whether I'm in prison.
Windhurst revealed that Melanie feared her abuser would harm her family if he discovered she had spoken out. Nevertheless, he apologized for taking matters into his own hands, acknowledging that he had acted as if he were playing God. He expressed regret, recognizing that he should have driven Melanie to the police chief's house instead of resorting to violence. In the end, Windhurst pleaded guilty to second-degree murder, hoping that his words of remorse and sorrow would somehow alleviate the pain he caused. However, even his attorney, Mark Sisti, acknowledged that forgiveness from the Paquette family might be a distant dream.
And this parole board thinks for a minute that the bill is paid and justice was served? Hell no. There's one place for you, and that's back in prison.
Windhurst was convicted of second-degree murder and sentenced to 15 years in prison with the possibility of parole. Meanwhile, Melanie herself served 15 months in prison for felony hindering apprehension. Samantha Davis, 32, was at the center of a devastating incident in 2016. While driving her pickup truck on Interstate 275 in Blue Ash, Samantha lost control of her vehicle while exiting the highway onto I-71, colliding with a cement barrier. The impact was so severe that Samantha was ejected from her truck, which then flipped over the barrier and plummeted onto a car traveling on I-71 below. This horrific crash claimed the lives of two innocent individuals, Sabrina Miller, 41, and her mother, Sandra Tell, 67, who were on their way to the University of Cincinnati's graduation ceremony. Adding to the tragedy, Samantha admitted to being under the influence of drugs at the time of the accident. Not only did she have to live with the guilt of causing such devastation, but she also had to face the legal consequences of her actions. Samantha faced 2 counts of aggravated vehicular homicide and 2 counts of aggravated drug possession. During the trial, a teary-eyed Samantha Davis seized the opportunity to address the court and apologize for the tragic consequences of her actions.
I want to apologize to both your family and mine for the ripple effect this has caused. I can't pretend to know the pain or hardships you have all endured these last 3 years. Although I may have my own, my mind is always flashing back to you and reminding myself that regardless how bad I might think I have it, you guys definitely have it worse.
In a deeply emotional moment, the victim's family found it in their hearts to accept Samantha's apology and offer her forgiveness.
A child in any case is painful. My children have lost both their mother and their sister, and every day it is difficult. I live with the knowledge that I will not get to hold her or to hug her or to hear her say to me, "Hey, Dad," when she greeted me. I want Miss Davis to know I do not hate her. I have forgiven her. I think justice, however, needs to be served.
I've gone through many emotions in regards to Samantha Davis. I have compassion for her children and family, and I would never wish on anyone what she's going through. I also feel that there needs to be consequences for what her actions have caused.
In 2019, Samantha was convicted and sentenced to 8 years in prison. However, her world was turned upside down again in 2021 when the First District Court of Appeals overturned her convictions on a technicality. They found that a crash reconstructionist police officer had given expert opinions during her trial without providing a written report to the defense beforehand. The court believed this deprived Samantha of effective assistance of counsel, leading to the reversal of her convictions. With her convictions thrown out, Samantha faced the prospect of a new trial. However, she decided to take a different path. Earlier this month, she accepted a plea agreement in which she pleaded guilty to the charges. Hamilton County Common Pleas Court Judge Leslie Giz upheld the terms of the agreement, sentencing Samantha to 5 years and 4 months in prison. Fortunately, she was given credit for the 43 months she had already served, meaning she'll spend an additional 21 months behind bars. Richard Jones's case is indeed a confusing one. Despite spending 17 years in jail for a robbery he didn't commit, every eyewitness to the crime identified him as the suspect. At first glance, it seems impossible for Jones to be innocent if multiple witnesses saw him commit the crime. However, upon closer examination, there's more to this mystery than meets the eye.
Jones was charged with aggravated robbery in Kansas City, Kansas, after being accused of trying to steal a purse in a parking lot. Jones had provided an alibi, and no physical evidence ever linked him to the crime. The victim told police the suspect was thin to medium build, tan with dark hair pulled back, and out of a photo lineup of 6 mugshots, Jones was identified. That eyewitness testimony landed him behind bars.
The absence of DNA, physical evidence, and a strong alibi couldn't outweigh the victim's identification of Richard in the lineup. Described as picture perfect, this situation highlights the power of eyewitness testimony, despite its flaws. Would you believe it if these were 2 distinct individuals?
We are back with a case of mistaken identity that forced a man to spend 17 years behind bars.
And the discovery casting doubt on his guilty verdict.
I believe it was a striking resemblance. It just blew me away. Couldn't let someone else's mistake make me waver in my faith and never make me shy away from what was real and what the truth was, and that was I was innocent, and I knew it.
After serving 15 years, Jones contacted the Midwest Innocence Project. With their assistance, they located the individual who had actually committed the crime, which shocked many.
That visit, Mr. Jones actually said to the students, "I keep getting mistaken for this guy named Ricky Amos.
The victim was brought back in to identify the suspect, with Jones and Amos standing side by side for comparison.
Jones and Amos had never met until a hearing last Wednesday when witnesses admitted they couldn't tell the two apart, and the judge ordered Jones released.
Judge recognized that an injustice had been done. Everyone did. The victim did. The original prosecutor did. And came to testify that Richard Jones didn't commit this crime.
It's truly unbelievable. The chances of encountering your real-life doppelganger, who not only shares your legal name, but also ends up in the same prison as you, are incredibly slim. It's a remarkable and unlikely twist of fate.
It's unbelievable. I didn't see myself being here. It's been 17 years. You know, something I didn't do, but I'm thankful. I'm blessed. I'm definitely built for the challenge, you know, just living my life, starting over and just doing it right this time.
In September 2018, Todd Grudznke, with a history of DUI offenses, was involved in a devastating crash in Lakewood. Tragically, the incident claimed the life of 25-year-old Angela Wimmer, a young woman with her whole life ahead of her. Todd was detained and brought to court to face charges for his actions. As if his crime wasn't outrageous enough, his reaction to his sentence added another layer of drama to the courtroom proceedings. Emotions ran high as the victims of the accident shared their heart-wrenching stories.
It's a lot, for me to be able to even drive again.
However, Todd's friends and family presented a different perspective amidst the anguish. They emphasized that he wasn't entirely a monster and claimed he harbored genuine remorse for his actions.
I've only known him to be caring and kind and helpful.
He has expressed his complete contempt for himself. He has stated how much he regrets the accident and would do anything to be able to change places with the victim.
When given the opportunity to address the court, Todd sincerely regretted his actions and offered a heartfelt apology to Angela's family.
I am so remorseful and so sorry that I did what I did. A few things I want to address real quick before I get into that. The victim has passed away because of my ignorance, and I am so truly sorry to the family, to everybody else affected, to Miss Martinez. I am so sorry for how much I'm hurting you, and I hope you heal fast. And we'll never get behind a wheel again. Call an Uber, call a taxi, or better yet, give up drinking.
His 6 previous DUI convictions did not work in his favor during the proceedings. The judge had to consider the gravity of the situation and Todd's repeated offenses. Consequently, the judge handed down the maximum punishment: life in prison without the possibility of parole. Todd's reaction to his sentence was shocking, and his accident tragically resulted in the loss of a life. This is Louis Prinzo, facing charges for the deaths of 2 individuals due to driving under the influence. In 2012, Prinzo, just 24 years old, was driving intoxicated with painkillers, anti-anxiety medications, and marijuana. His reckless decisions led to a violent crash on Interstate 95, claiming the lives of Meredith Smith and another teenager, Lane Bernst, with 2 others injured in the accident. With aspirations of attending Princeton University, Meredith had her bright future tragically cut short by Prinzo's actions. As the trial progressed, emotions ran high.
This accident took from me all of the milestones: her college graduation, her first position in a career, any marriage or children.
She wanted the judge to see the face of the young life that was stolen away too soon. It was a heartbreaking moment that left no dry eye in the courtroom. Then came Prinzo, the man behind the wheel that fateful night. He stood up and read a prepared statement.
Not a day goes by that I don't suffer from the guilt. It is such a horrible situation, and there's nothing I could do to fix it or make it right. I know that I'm going to be sentenced to a lengthy prison sentence. I accept that. Just as I've accepted the responsibility for my actions.
Despite their immeasurable pain and loss, the victims' families displayed incredible compassion and forgiveness. They did not demand the maximum sentence for Prinzo, but instead trusted the judge to make the right decision.
We understand that people make bad decisions, and we get it. And he'll forever be in our prayers, his family. And but by the same token, there has to be a sentence. There has to be There has to be a punishment.
As the trial reached its conclusion, Smith's father, Robert, expressed gratitude for the community's support and acknowledged Prinzo's apology. He recognized that accidents happen, but couldn't overlook the burden of grief his family had to bear. Finally, the judge delivered the verdict. Louis Prinzo IV was sentenced to 16 years in prison with an additional 19 years of probation. Upon release, he was also ordered to pay $8,000 in restitution and faced a 5-year driver's license revocation. A kid's trust in the world begins with the comfort of a mom's embrace, but sometimes moms like Brianna can seem like mysterious shadows, casting doubt on that trust.
There is evidence in the record then to draw a reasonable inference that although were present and the latter was documented in the bathroom.
In 2019, in Duval County, she ended the life of her daughter. Now, it's up to the judge to ensure justice is served. After a long trial, the judge gave out a punishment.
Tragically common for those that appear before me. The evidence offered by Dr. Bedini was not offered as justification, but as a way of explanation, and the court accepts it as such. He acknowledged that his opinions are based on objective analysis as well as subjective opinions. That's why he's an expert. Multiple diagnoses were rendered, and the court has taken all of those, all that testimony into consideration. One of the things that the court asked was whether or not the diagnoses and findings were descriptive or predictive, and he said both, meaning that it provided a context for the crime, but also it would continue to persist, which means that given the right circumstance, it creates concerns for me regarding danger to the community. To the extent she might find herself in similar circumstances with ongoing psychiatric issues that are unresolved, it creates the possibility for a repeat offense. The court takes that into consideration. Beyond that, there was not additional mitigation offered for the court's consideration of any consequence. The state offered essentially an aggravation of the circumstances surrounding the crime itself in light of the relationship that the defendant had with the victim, her daughter. The court heard testimony over several days regarding the substance of the investigation. There was no opinion regarding cause. There could be no expert opinion because the defendant disposed of the body in such a way that it prevented any analysis that would result in an expert opinion. That does not mean that the court cannot draw its own conclusions. And so based on the following factors, I'll tell you the conclusion that I believe most appropriate. Again, in considering the allegations of second degree, the evidence before the court is that the victim was not valued from the time of conception by either her father or mother, that her mother suffered, the defendant, from an eating disorder, that the father complained that the victim was not being properly fed. The defendant then removed the victim from daycare approximately 4 months to the victim, prior to the victim's death. Taylor remained home alone and unprovided for throughout that time period. There was no significant purchase of groceries during that time period. There were some fast food purchases, but no more. No significant food in the home or the apartment. The food present in the refrigerator was unfit to eat. There's a hole in a juice can from which, well, there's a hole from a fruit can from which juice could be consumed. That was an argument made by the state, and that is supported by the record. There were photos submitted for the court's consideration, and I did notice a change in the child's appearance, particularly immediately surrounding the time of she appeared small and as if she were losing weight. Again, we have no opinion regarding the cause of because the defendant acted in a way that prevented that review. According to her testimony, she found Taylor Rose slumped over in a closet, unresponsive, and she knew that she was. Thereafter, the defendant failed to report the of her daughter. She then lied to law enforcement repeatedly over the course of the investigation in order to conceal what she had done, which was to transport the body out of state and dispose of the body, which this court construes as a consciousness of guilt. When the bones of Taylor Rose were analyzed, they were consistent with malnutrition. There is evidence in the record then to draw a reasonable inference that although were present and was documented in the bathroom, the death was in all probability a consequence of starvation. There was a failure to act where you have a duty to act. You had a duty to provide care for your child, including the provision of food, and over the course of a 4-month period failed to do so, resulting in her. Considering the aggravating and the mitigating factors, wanting to ensure that the community is protected and that the sentence is rendered in a way that does not dishonor Taylor Rose, the court sentences you to life in prison. Madam Clerk, can you give me credit for time served, please?
We have 1,043 days, Judge.
1,043 days credit for time served. You'll pay $600, correct that. Madam Clerk, is it $518?
$518, $150.
$518 and $150 public defender fee. Are you asking me to convert it to a civil judgment?
Yes, sir.
I'll convert the matter to a civil judgment. Ms. Whims, I take no pleasure in pronouncing the sentence. You have 30 days from today's date to take an appeal of the sentence if you believe any portion to be illegal. If you can't afford an attorney for that purpose, I'll appoint the public defender to represent you. It's a tragedy all the way around. I wish the families well. Anything further from the state?
No, Your Honor.
Anything further from the defense? You're adjourned. Thank you all.
You are about to confront someone who sees life as a whisper in the winds of greed, where conscience holds no value.
Drew Blahnik, Johnny Church, whatever your name is, it doesn't change what you and your co-parts did to my husband, my best friend.
In 2018, in Cedar Rapids, Drew Blahnik ended the life of Chris Bagley. Eventually, all actions come to light. In this case, the prosecution revealed everything Drew had done to the victim in court.
Christopher Bagley was 31 years old when he was. He did not die from natural causes. An autopsy showed that Christopher Bagley was 17. Many of those wounds were to the neck and torso. The facts will show that Christopher Bagley suffered a violent and brutal end to his life. The facts will also show that after Chris Bagley was in the backyard of one of the suspects. He was in a desperate attempt to hide his body and the evidence of the crime. We will prove when, where, and how Christopher Bagley. More importantly, we will prove who Christopher Bagley. The facts will show that the defendant, Drew Blahnik, stabbed Christopher Bagley and that it was not an act of self-defense. The facts will show that the defendant was also working with an accomplice to kill Christopher Bagley. Courtney Bagley remembers the last time she heard from her husband, Chris. It was a text message she received on December 13th, 2018. In that text message, he said he loved her and that he would see her the next day as they had plans to go Christmas shopping for their children. Chris loved the holidays. He never showed up for that shopping trip. Although Courtney did not know it at the time, when she was waiting for Chris to show up, he was already. Courtney Bagley did not report Chris, her husband, missing right away. She was holding out hope that there was a reason for his absence and that he would show up. But on December 17th, after not hearing from Chris for a few days, which was unusual, she reached out to a friend, Dan Castle, and together they filed a missing person report. A deputy with the Lynn County Sheriff's Office met them, took the report, and started a sequence of events that turned this from a missing person case into a homicide investigation. The facts will show that Christopher Bagley was in the early morning hours of December 14th, 2018. He was in a trailer owned by Paul Hoff in the 7100 block of Mount Vernon Road, Cedar Rapids, Iowa. The facts will show that earlier that night, Christopher Bagley was picked up from his residence by a friend by the name of Lydia Oline. The two of them proceeded to Paul Hoff's trailer, where Paul Hoff was with another female by the name of Chris Marty.
After being proven guilty, Drew Blahnik had the chance to speak.
I would like to apologize. I would like to apologize for everything that happened after I killed Chris. You see, Chris made this choice that night to pull that, and in doing so, he paid the ultimate consequence. And for that, I cannot, will not apologize for following one of life's most basic human instincts: survival. I'd also like to point out that the Bagley family here has been blindly following these prosecutors, these county attorneys who are supposed to be seekers of truth, but instead engage in backdoor shady deals with degenerates who they know are 100% lying just to get a conviction. Monica Slaughter here even stooped so low, she came over to the jailhouse during trial to try to convince one of the state's witnesses, Raven Burkow, to lie for her and change his statement to best fit her needs, her agenda. And you know what she did when Raven refused to lie for her? She had him thrown in the hole for the duration of his stay. Lynn County, of course, didn't use him as a witness. Also, we now know that the famous Allen charge given by the court did in fact have a direct bearing on the holdout juror decision to change her verdict. Juror number 8, Dana Carr, has come forward since trial to sit down with my attorney for an interview. In this interview, she clearly outlines the abuse that she was subjected to during deliberations. More importantly, she also states that she would have held her ground if it wasn't for the court's decision to give that Allen charge. In that moment, she felt defeated. Not only did she feel that all all the other jurors were against her. She felt at that moment the judge was against her too. And the only way to stop that abuse would be to finally cave in and change her verdict. A verdict she never wanted to give. A verdict she never would have given if it wasn't for the court's outside influence, the Allen charge. So, these are the people who have been entrusted to stand up and serve justice in our community. Well, I'm here to tell you, justice wasn't served here in this courtroom. Because justice was served by me December 14th, 2018.
A wife never fully recovers from the pain of losing her husband. While others might move on from the loss of a loved one, she never does.
Drew Blahnik, Johnny Church, whatever your name is, it doesn't change what you and your co-parts did to my husband, my best friend, my children's father. I want you to take a look at some of these pictures. While I'm aware you don't have kids, and thank God for that, you may not understand the complexity of these photos, but I'll take a few moments and I'll explain them. Can I have somebody hand these to him? Is it possible?
That would be, you can hold it up, yeah.
Okay. These pictures right here. This is a dad when he met his kids for the first time. He was there. He loved it. The pride on his face shows how happy he was to be a dad. The second one is the fun that he loved to have with his kids at their birthday parties, especially. Always had water balloons, silly string, loved it. This one, he had a whole bag of silly string, and him and his brother shot the birthday boy with silly string all day, and they loved it. Now, this next one, that's my daughter. That's the first Christmas, 12 days after you took her dad. You see that little smile on her face? That's all she could muster up for a smile that day, because she wanted her daddy there. You were probably with your family or on a bender. Chris was in the ground at your friend's house after you took his life. That Barbie dream house, we purchased that for her. Sorry, give me a second. It was the only thing that she wanted for Christmas. When it came in the mail, Chris told her it was his new bike. I've never seen the guy ride a bike in my life. She was so sad, she started crying, saying, I just want my Barbie dream house. She was so excited. She came up to me and said, Mama, can you call Daddy? Santa listened. Sorry, my throat burned and I choked back tears, fighting my anxiety and my urge to cry because she was so happy. I sent that text to Chris and I told her that I told Daddy to call her. I knew he wouldn't. He wouldn't have missed this moment. Holidays were his favorite. And he would never, ever have missed this for the world. The last set of pictures are my kids. This was last year, during one of the random holidays. That's how they go see their dad now. They see him at a cemetery. That's where they have to go to tell their dad, Happy Father's Day. We also go there for his birthday, our anniversary, and randomly, when the kids are, I just need Christopher Bagley. What you may have saw was an addict, someone not worth living, apparently. What we saw was a dad, a husband, a son, a brother, and a friend. Everyone that was friends with him talks about how he'd do anything for anyone, even if it was his last $10 and it didn't benefit him. I mean, you would know that. He helped you move into the loft. How he was always a joke or a prank away from getting someone out of a bad mood on their worst day. When you took him away from me, I was terrified for my life. The life of my children, my family, and even my dog. Since then, I've sold my house. I bought a new one. I graduated nursing school. And I've made tough decisions. Tough decisions I should be making with my husband. This has made me strong, to the point it's scary. I don't want to be strong. I want to share my children growing up with my husband, to meet our new niece and nephew that we've had with my husband. Talk to him when I'm having a bad day. But you took everything away from me and my kids and I's future.
The grief of losing a family member can make it difficult for relatives to accept.
I would like to take this opportunity to thank the court for letting me speak. I also want to thank Dave Buter of the Linn County Sheriffs and the task force he put together of local, state, and federal law enforcement. Next is the great work of the county attorney's office. Jerry, Monica, Jennifer, Anastasia, wouldn't be here without you. And next is Monique from New Horizon. Monique, you've been with us since that first day in the sheriff's office when they gave us the devastating news. You have become one of our family. Where to start? The coward's lawyer has made such a big deal about the coward being in the Army. Well, if it was such a big deal, why didn't you enlighten us? Well, I'll take my youngest son's service in Afghanistan over yours any day, and twice on Sundays. Ask me, it's a big acting job by you. Next, the coward's lawyer kept bringing up about him having a concealed permit. That's no big deal. I have one, same as most of my family does. He also said how Chris was running around looking over his shoulder and acting paranoid. Well, if you had a $30,000 hit put out by your boss, Andy Shaw, you would be running around looking over your shoulder too. And I know the feeling because I had one on me too. Well, you know, a lot of things have happened and were going on at that time. Everybody involved was doing all kinds of stuff to my family. We were being threatened, told to back off. Asked my son about almost being run off the road February 22nd, 2019. Because he had words with your boss. At the same time, why don't you ask the 3 or 4 others that had prices on their heads? Were you going to take them out too? You did all this for and money. Your lawyer also said how you've been drinking since. Well, I did a little looking. You've been drinking for a long time. You got 3 OWIs, multiple driving while suspended, probation violations, and possession of a dangerous. It's all smoke and mirrors to make you look like an angel that you are not. Our family has endured so much from the coward's friends/family, especially Colin Harms has been verbally threatening from the first day in court. Then after court on December 3rd, confronted one of my sons. John, my son John, and a friend tried picking a fight with them. Well, he found out that outside the court, the Bagley family will not back down. I don't think he liked being back down the street, the middle of the street, for a half a block. All mouth, no action. My warning to you and the entire family and anybody else listening, come after my family, the results won't be good. We will put you down.
Remember, you will face harsher legal repercussions for your heinous actions. It is the judge's duty to decide the offender's fate.
On count 1, I sentence the defendant to be confined for an indeterminate term not to exceed 50 years. Pursuant to Iowa Code Section 902.12, I will order the defendant to serve at least 70% of that sentence before he is eligible for any kind of release. On count 2, I sentence the defendant to be confined for an indeterminate term not to exceed 2 years. On count 3, I sentence the defendant to be confined for an indeterminate term not to exceed 5 years. I make all the prison sentences consecutive with each other, and here is my reason for doing so. Count 1 is a discrete offense. Counts 2 and 3 were committed subsequent to count 2 with the expressed intent of avoiding criminal responsibility for count 1. It would make no sense to at least not make those 2 counts run consecutive with count 1. As it regards why I am making counts 2 and 3 consecutive with each other, I am doing so because they also form a distinct pattern of conduct. The abuse of a corpse occurred earlier. The obstruction of prosecution continued basically up through the point in time that the body was found, and the defendant ultimately admitted to law enforcement that he had been enrolled in the, and for that reason, those offenses should carry consecutive sentences. I place the defendant's custody with the director of the Division of Adult Corrections and his temporary custody with the Lynn County Sheriff. There is no fine for count 1. On counts 2 and 3, I set the fine for count 2 at $625. I set the fine for count 3 at $825. I impose the 15% court services surcharge. However, I am imposing an extremely substantial restitution obligation in this case, and I have no expectation that in light of the prison sentence that the defendant will ever even be able to pay his restitution obligation. That obligation must be paid before any fines would ever be paid. And because I believe there is not a snowball's chance that these fines would ever be paid, I suspend the fines and the surcharges. The defendant will be given credit for all qualifying time previously served as certified by appropriate individuals. The defendant's term of incarceration may be reduced for statutory good conduct time, work credits, and program credits as provided in Iowa Code Section 903A.2, subject to the minimum sentence required by Iowa law in this case. I order the defendant pursuant to Iowa Code Section 901.5 to submit to a DNA test upon request if he has not already done so. I will set victim restitution in the amount of $19,500 to the Crime Victims Assistance Program, $3,525 to Stuart and Christine Bagley, and $150,000 to the heirs at law of Christopher Bagley. I will set a separate hearing on Category B restitution. I do assess at this time all costs to the defendant, subject to a determination as to his reasonable ability to pay. If there was previous bail, which I do not believe there was, it is exonerated. There is no appeal bond set because this is a forcible felony and no appeal bond is allowed. Mr. Vanderstanden, before I cover rights of appeal, is there any further record I need to make on sentence?
No.
Mr. Spies, anything you notice that I need to cover?
No.
Mr. Blahnik, you have a right to appeal this case to the Iowa appellate courts. If you can't afford to pay the costs of appeal, you have the right to apply to this court for the appointment of counsel and the furnishing of a transcript of proceedings at state expense. All those rights are set out in Iowa Code Chapter 814. To begin an appeal, you must file a written notice of appeal with the Lynn County Clerk of Court, that's the clerk in this courthouse, within 30 days of today's date. Perfection of your appeal in that manner is jurisdictional. There are also other provisions in the Iowa Rules of Appellate Procedure and Iowa Code Chapter 814 which apply to appeals, and if you violate those provisions, it could have a negative impact on your appeal. If you do appeal, a copy of the notice of appeal must be served on or delivered to the Iowa Attorney General, and an informational copy must be filed with the clerk of the Iowa Supreme Court, but the original will come here to Lynn County. I will make all amounts due and payable today because a payment plan makes no sense in light of the defendant's incarceration.
In the scales of justice, no excuse outweighs the weight of a crime. Behold his story, a testament to the consequences. Judge Cedric Simpson faces a confrontation when a boyfriend throws his girlfriend out of his house. During the proceedings, the girlfriend starts crying.
Ms. Tharp, what's your position on the termination?
Your Honor, I already moved all of my things out. This wasn't an issue when he said he wanted me out, and I got the eviction at my father's house on the 16th. I have gotten everything out of the home. I have nothing left there.
Okay.
She moved all of her stuff, the last of it on Tuesday. So I'm here basically for my keys and for an understanding that she's not allowed in my house anymore, so I can change the locks.
Okay, so let me ask you this, ma'am. Do you have the keys or
I do have the keys. He's made this process extremely toxic. And
okay.
I don't want to go to the house to give him the keys. So is there any way I can?
I'm Miss Tharp, I didn't hear you. So can you repeat what you just said?
I don't want to have to go to the house.
Okay.
All
right, fair.
I don't have a problem with that, but if I can drop them off somewhere else or at the police station, that's
all right. Ms. Tharp, let's do this. Can you put the keys in an envelope? And do you know where my court is? The 14A1 court at the Sheriff's Department?
Yes, I do.
All right. What I'm going to do is I'm going to mark in the file that the defendant will drop keys at the court.
Yes, sir.
I also have his son's spare truck key as well. So should I put that in there too?
Put whatever keys.
Okay.
Okay.
That's not all she has. She also has my house key. I have my primary residence is in Grand Traverse County. She has, and she doesn't has.
Hold on a second. What's the relationship here?
We used to be boyfriend and girlfriend, and I'm just trying to get my life back to normal. But I have a second house that she has.
I'm not here as a divorce court. I'm here on this case.
Thank you.
Okay.
I will give him all that I have. I do not have a problem with that. I just want this over with.
Oh, I know. I got you, Miss Star. Just put whatever, so the only keys, the only keys that need pursuant to my order to be returned are the keys to this premises. Whatever other thing you guys have left from your relation, I could give a darn about, because I'm not here to resolve that. Ms. Tharp, whatever other keys you want to put in there, okay?
Okay.
You can just put them in the envelope,
Okay.
okay? But what I'm telling you is you can put them in there, you don't have to. The only keys I'm requiring are the keys to this premise.
To the house.
If there's a truck key, if there's a key to some other place, I don't have jurisdiction over that, and I'm not doing it.
Okay.
Okay? So when do you think you can get them to my court?
I can drop them off today.
All right, so you're gonna do that today. Can you apprise the clerks that that's gonna be happening? Just put it in an envelope, drop them off. And then, sir, you can pick them up here on Monday with ID.
Perfect.
Okay, so once that's accomplished, that's done. And then this case will be dismissed.
Okay, thank you.
Got it? Okay.
This is Ryan Lyles, accused of barricading himself in a Gaffney home with 3 children. During his bond hearing, he becomes unruly, and the judge repeatedly tells Lyles to remain quiet.
I will tell you right now, the victim is present in the courtroom. She has a right to be here. And she is present. I will ask you not to speak to her, and she will not speak to you, okay? The condition of your bond is there is absolutely no contact with this young lady or her children during this time. If you have visitation or whatever with the child that's yours, you have to have a third party bring that child to you. You two cannot exchange the child. Do you understand that? Your mama can pick it up from her mama or somebody, but you two cannot exchange the child. Do you understand? Okay? I've got the solicitor's office in here as well, Mr. Lyles, and I'm going to ask them if they have anything they would like to tell me before I consider what your bond might be. Ms. Berry?
Thank you, Your Honor. May it please the court. This occurred between the hours of 8 and 11 o'clock on April the 17th of this year. Law enforcement responded to Willow Street here in Cherokee County in the city limits in reference to a 911 hang-up. When they called back, they could hear a female and a male arguing, so law enforcement responded to that address, and it quickly turned into, for lack of a better term, a hostage situation.
Okay.
Law enforcement could not get close to the house. Mr. Lyles was not allowing anybody near the house. He was not allowing anybody to come out of the house. They could hear, they were able to get him on the phone.
Okay, hang on, let her talk. Let her talk.
A couple of times, they could hear him talking to the victim, and the victim then talking to Mr. Lyles. When she asked to come out, he told her, well, if you leave, I'm going to kill you. He did have a firearm.
Okay. Mr. Lyles, I'm going to tell you that everything you say can be held against you. Please be quiet. I'll let you talk in a minute. Let Ms. Berry finish.
He did during this incident, Your Honor. He would point it at the victim, and the victim did tell law enforcement this morning that he was pulling the gun just happened to misfire. He would then point it at the ground and pull it. And what ends up happening is, at one point, the lights go off. When law enforcement is asking the victim if there is a, they're asking, is it in this room? Is it in this room? She's saying no. When they ask if it's in the kitchen, she doesn't answer. When the lights go off, they're off for a couple of minutes and they come back on. And what ends up happening is he takes from the kitchen and he hides it in a vent in the living room. So law enforcement has been able to recover that.
Okay.
There were 3 children involved in this incident. So the kidnapping victims are Miss and then the 3 children. one of the children that is the child in common between Mr. and Mr. Lyles.
Okay.
Your Honor, the standoff lasted.
What did I tell you about being quiet? And I will tell you again.
It lasted about 3 hours before came out with the children, and then Mr. Lyles did come out. Your Honor, I do have Mr. Lyles' criminal history. It begins in 2013 with a miscellaneous criminal offense. 2014, he has a resisting arrest. And also in 2014, with burglary second degree and petty larceny. 2017, hit and run with property damage and burglary in the second degree. Also from 2017, failure to stop. 2018, domestic violence in the third degree. Also from 2018, failure to stop for a blue light. 2 counts. 2022, domestic violence in the third degree. And 2023, burglary in the second degree, non-violent. So Mr. Lyles has a history of domestic violence. I actually remember his name as it has come through the solicitor's office several times. Mr. Lyles is a danger to this community. He's a danger to, for sure. And there's also questions that he may be a danger to himself. I believe that Mr. told law enforcement he seemed to be under the influence while all of this was going on. And he's certainly a flight risk with his failure to stop convictions on his record. So at this time, Your Honor, we would ask that bond be denied in this case, and any bond that is to be set by the circuit court, Your Honor.
Okay. Very much. Anything from the Victims Advocate's Office?
No, ma'am.
Okay. Law enforcement, you have anything to add? Okay. All right, Mr. Lyles, you had a chance to hear Ms. Berry and what she has been given by the officers. Now, you remember that preliminary hearing I told you about? If you want to hear the state's evidence against you again, you can do that. It is an optional hearing. You can't testify at that hearing either, but you get to hear more of the details of what happened and how they got the warrants. Your lawyer can also be present for that hearing, okay? Because I can't let you talk about it right now because this is not a trial. It is just a bond hearing, all right? So do you understand that, why I can't let you speak? If you've got a question about what I've told you, that's fine, but you can't ask me any questions about last night or what Ms. Berry said.
No, I'm just saying. I just had a thought on last Thursday. I don't need to be here.
Okay. Okay. And that's all right. And you're going to be able to tell your lawyer that, and your lawyer can help you deal with that. I can't. Okay. But based on the information that I have, Mr. Lyles, you will be remanded to the Cherokee County Detention Center without bond. All right, circuit court judge will set you a bond. It won't be tomorrow, but he will set you a bond later. Do you have any questions? I'll send you your paperwork down to you very shortly. Okay? All right, you can go now. You open the door, let Miss Berry let you out. I'm just going to cut it off.
Thank you, Your Honor.
You did good. She learned something? She's good, isn't she? She's very good. She's very good.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.